Hi, everybody. I'm Arvind Swaminathan. I'm the global co-chair of Oryx Cybersecurity Data Privacy Practice. I am based in Seattle. And just quick by way of introductions, and I'll let Mark introduce himself. I'm a former federal prosecutor, and I'm actually a white-collar criminal defense lawyer as well as a cybersecurity incident responder for our clients. So I'm on the legal side. So we help clients from all manner of cybersecurity incidents, from compliance issues at the beginning to crisis response, all the way through the litigation and regulatory enforcement actions. And just today, my experience and how I'll be speaking to this issue is partly with my background as a federal prosecutor, partly with my background as a white-collar criminal defense lawyer, partly with my background as a lawyer in the cybersecurity incident response space, and then also having represented individual CISOs in particular around the issues that we're going to talk about today. So, Mark, I'll hand it over to you.
Thanks, Arvind. So I am currently the Chief Information Security Officer at Alert Enterprise and also the Chief Strategy Officer at the National Cybersecurity Center. But I've been a CISO or CSO 4 times previously, in addition to a couple of other senior security kind of roles. So Arvind and I have given this talk or a similar talk to this a number of times, but this year it's a little bit more important, I think, and we'll get into some of that as we go along here. Why don't you go ahead and go to the first slide then, Arvind. So as I said, we've done this a number of times, but I think, the recent charges against Joe Sullivan when he was at Uber have raised the bar for CISOs, and really they should be attention getting for everyone. At least for every CISO. And for ease of conversation, I'm going to use the term CISO and CSO synonymously, but rest assured, I do know the difference. So I like to ask, and not that you can answer me, but how many calls have you been on in the past year or two where you were concerned about CSO liability? And I know that Arvind and I have talked about this a lot. We've been on a number of these kinds of calls. So we're going to talk today about a lot of the pre-employment questions you should ask, and probably some of the legal issues that you should be concerned about as a CISO today. And I guess I would just kind of set the tone with this. Following an incident and during the incident response, you are the company and the company is you until something bad happens. And that's when you're going to be the first person that gets shot. So go on to the next one, Arvind. So, these are just a few of the examples that highlight the employment and financial liabilities facing CISOs today. The target, every one of these things have had implications for, and not just for the CISOs involved with them, but really for all of us, for everyone in the CISO community that has had to deal with these or deal with questions of these. Because I expect, and we're going to talk about this a little bit more later, I expect that anybody that reports to the board has had questions from the board about, okay, these different breaches, could these happen to us? And if they did happen to us, how would we respond? How would we react to them? So these are not new. We've just in the past week dealing with the Colonial Pipeline incident. The ongoing implications of this are just now starting to come out. So it's going to be interesting to see how liability points back at the security team and the security professionals at Colonial.
And I think just to highlight something that Mark said, right, there's a headline here about the most recent incident involved AOL CIO, which some of you don't even remember AOL, but that article was from 2008, right? And so there's been discussion about this for quite a long time, to Mark's point, but it's now I really think that we're coming to a head. And here's what we're really looking at, right? So today what we're going to talk about are predominantly criminal issues. We're going to talk a little bit about some of the civil issues, right? But we're really going to look at criminal liability, largely in the landscape or in the wake of Joe's case. But these aren't really new. So when we what we're seeing is a bunch of different theories on which liability could be premised. And on the criminal side, right, and again, for those of you that don't know the difference between criminal and civil, right, criminal is you go to jail. Civil is you pay money, right? Now, you can also pay money with criminal, but criminal is really somebody's butt is going to land behind bars. And when you're looking at those charges, we're looking at things like false statements, securities fraud, mail and wire fraud, and then as we'll touch on in just a second, two theories that have come up in Joe's case, which are obstruction of justice and misprision of felony. So just to be clear, this is not all about the case at Uber. What we're going to use though is we're going to kind of go through a couple timelines of events just so people who are in the audience can level set a little bit, right? Understand kind of what's the context that Mark and I are talking about here. So most of you may have already read the indictment. And so everything I'm about to say regarding Joe Sullivan's case is all allegations. These aren't proven. He's innocent until proven guilty. He's got a criminal trial that will be coming up probably late summer or in the fall. And so these are the allegations that the government has stated, right? And most of these are pretty familiar to folks that kind of know this story. Uber suffers a breach. Joe Sullivan takes the helm in 2015. He provides testimony to the FTC. Later, after the testimony, hackers email Uber about a new security event. Joe Sullivan updates the FTC about the old event, right? Not on the 2016 event that came on November 14th. They pay the hackers $100,000 for the bug bounty program in part of their bug bounty program. Uber identifies the hacker. They get him to sign an NDA. And then what happens is the problems, which is the FTC then makes further inquiries. There's no disclosure at that point of the 2016 event. Dara takes role as the CEO in 2017. And then the 2016 event is publicly disclosed. So those are essentially the allegations, right? And if you were to just microcosm those for a moment, they are one breach. You have regulatory obligations and are talking to the FTC in particular, new breach, non-disclosure to the FTC, and the charges arise out of that. We'll talk a little bit about those as we move on. Yahoo's another case study where we have a very similar kind of fact pattern, right? You have a 2016 event where Verizon's going to acquire them. And then right after that is the first disclosure about an event that occurred back in 2014, right? So again, what's the common theme? These are events that aren't disclosed. The common theme is these two events are events that aren't disclosed kind of right in time with when they're happening. And that sort of creates the problems. In Yahoo, the board initiated an independent investigation. It interviewed witnesses. There was an announcement of a second breach. As that investigation was ongoing, Yahoo files an SEC Form 10-K, which we're going to talk about in a little bit in some more detail. There's shareholder derivative actions. So these are lawsuits that are filed, right? These are civil lawsuits where shareholders are saying saying to Verizon, you're paying too much money for Yahoo. Look at this breach. It's not worth that much. The purchase price ended up getting lowered by $350 million. The SEC is conducting an investigation. They settle with Yahoo. There is, meanwhile, by the way, also a criminal investigation that went on at the same time. We're going to talk about a little bit about. And then Yahoo announces settlements of the class action. Your third story, again, not anything that people aren't familiar with, are Equifax, right? And again, the breach gets announced, the shares plunge. There's immediate retirement of the CIO and the CSO. You have Equifax announcing to customers. There's a series of investigations. The CEO then retires, and you get a whole series of cavalcade of incidents, the most important of which are that the former CIO is charged criminally with insider trading. And again, we're going to get to that as well in a second. So just so folks have an idea, these three events are sort of a microcosm for breaches that we see all over, right? Some of them are not as big, obviously, as Yahoo or Equifax. They're not as well publicized, but it doesn't mean that the stakes are any less, right? These happen to be the ones that are most discussed, most talked about, ones that people are most interested in. But we have been involved personally with a number of other security events where either the SEC or the DOJ, right, so a civil enforcement authority and a criminal enforcement authority, are looking at C-suiters, particularly the CISOs, and asking themselves, do these folks have any personal responsibility? In other words, should we hold them personally responsible for the issues that came up in the situation, whether it's civilly or criminally? So from just those three, there's a whole series of legal ramifications, right? And let me just talk about what each of these are really quickly. So we've talked about a DOJ, Department of Justice, criminal investigation and prosecution. There are security class action litigation. So that is when shareholders bring a class action against the company, saying essentially that company executives misled them, failed to disclose important information that impacted their decision to buy or not buy the stock, and then caused them damage when the stock price changes post disclosure of the event, right? So the event gets announced, stock price goes down, shareholders are angry because if they had known, if they had known something that you didn't disclose, they claim they wouldn't have bought it or would have sold it earlier. Shareholder derivative litigation is a different kind of related litigation where the shareholders actually step into the shoes of the company and sue the board of directors and the management and say, you guys personally failed in your fiduciary duties. So that's a situation which is a little bit of a sort of a legal contrivance, but that's another type of civil litigation. There are consumer class actions. We're all pretty familiar with those. That's where consumers who are people whose information was lost decide to sue. There are congressional hearings, more and more coming up, right? Where individuals are hauled in front of Congress and have to actually testify about what happened. And then there's a cavalcade of regulatory investigations, right? Federal Trade Commission, state attorneys general, SEC, right? And then if you are regulated internationally, ICO, Turkish Data Protection Authority. So there's a whole list of, three-letter alphabet list of entities that can bring litigation or pursue responsibility for individuals. Okay, we're going to dig in really deep to the Yahoo case, just to talk about that one for a little bit. Okay, so as I mentioned before, in Yahoo, what happened was around September, the event that happened in 2014 was discovered. And the board initiated what's called a special investigation committee to investigate the instance. So they hired their own lawyers who went out and collected hundreds of thousands of pages of documents. They interviewed dozens and dozens of employees, right? One of which we represented in the case of that investigation. And they did an independent investigation and came up with findings. And in sort of a rare step, the company disclosed those findings in a public filing, right? And so the public filing, so the investigation happens, late 2016, and then in early 2017, they release a 10K. And here's what the key parts of it are. The information security team had contemporaneous knowledge of the 2014 compromise of user accounts. The InfoSec team understood that the attacker exfiltrated copies of user database backup files containing personal data of Yahoo users, but it's unclear whether and to what extent such evidence of exfiltration was effectively communicated and understood outside the InfoSec team. The independent committee did not conclude there was an intentional suppression of relevant information. The 2014 incident was not properly investigated and analyzed at the time, and the failures in communication, management, inquiry, and internal reporting contributed to the lack of proper comprehension and handling of the 2014 incident. So that's what the special committee found, and the company publicly announced that. So, Mark, I'm going to ask you to put yourselves in the shoes of the chief information security officer at Yahoo who oversaw that breach, or any of the incident responders. And, what's your thought coming out of that? What just happened? What did the company just do?
Well, the company just put the security team on report, as we would say in the Navy, and and basically, I think exposed the CISO and the security team to further litigation potentially. But I would, and so this is really important in the Yahoo case. But and this is a question I ask to CISOs all the time: is how many people actually help write the 10K and the 10Q forms? Because, if you haven't read these things and before they get published, you are missing something really, really relevant. I remember the first time I read a 10Q, I almost had a heart attack. There were, things in there that I would never in a million years put on paper about threats and vulnerabilities and incidents. And these 10Qs and 10Ks, they're almost always completed by the legal team, but the CSO, I mean, as you see right here, you have responsibilities in here. So if you don't have any input and really editing authority, you're accepting a lot of liabilities that you may not understand. So I always advise people to make sure that they have actual editing authority on the 10Ks and the 10Qs, because they typically just talk about risks and the risks that may be that you may be responsible for. But when you get into really details like this, sometimes these things can come back and bite you in a big way.
And it's such an important point, right? I mean, here is the company essentially throwing not just the CISO, not just the head of incident response, but basically the entire IT security team under the bus, right? Which in 2017, this was March of 2017, reputationally could be disastrous, right, Mark? I mean, that's the other thing, which is they basically called them to the carpet and said, these guys didn't do what they were supposed to do, right? And that's based on their own internal investigation, right?
And, and something you may remember, you mentioned earlier, about congressional hearings. All these guys ended up doing the congressional perp walk. They had to go and explain to Congress, explain to legislators, what happened and why they did this, explain to the SEC. And, we'll get into this a little bit more, but, these things happen sometimes years after the fact. So sometimes it's hard to remember exactly what happened in the heat of an event.
Yep, exactly. So Mark, let's take a look at, and you can address a little bit of these, how other companies have reacted publicly when they've had similar instances.
Yeah, I mean, so again, these are just, go ahead and click on the next one. These are just the kind of instance that how these things are communicated to the public can really have implications long after the initial disclosure. So making sure that these communications are crisp and to the point is critical. And, just like you see here for Uber, we continue to fully investigate, the DOJ's or cooperate with DOJ. And then the other one, we launched a review of these things, if they're worded, if there's nuance in the wording, it can really make the CISO or the security team look bad.
Yep. Yeah, exactly. There's a couple questions in the chat I'm just going to flag here. There's a question also about the legal team and how Yahoo treated the legal team. And I'm going to get to that in a second when we talk about the SEC's findings in just a moment. And then there was another question in the chat, Mark, about having members of the security team have direct input into the public SEC filings. And I think you talked a little bit about that, but maybe it's worth just spending another second here to talk about the process that you would go, that typically you've gone through when those filings are getting ready, and maybe just talk a little about that. Then I'll add a little bit of color to that.
Yeah, in my last company, it was about, usually it's like 8 weeks before the end of the quarter. The legal folks would draft up, the 10Q, and they would send it over to me and say, okay, here's the risk. Have there been any incidents that should be made, that should be publicly acknowledged? Anything of any significance that shareholders should be aware about? So that was my opportunity then to go in and say, okay, the threat and vulnerability environment hasn't changed substantially since last quarter. We haven't had any security incidents that were of significance that would impact shareholders' positions. So it was just my opportunity to go in then and highlight the things that I wanted to highlight. And sometimes, actually, probably more often than not, we had this kind of pro forma. These are our risk categories, and this is our risk status. And I would go back and say, well, wait a minute, ransomware has increased 30% in the last quarter. So we need to acknowledge that in our 10Q that we are at a higher risk of ransomware events just because of the global ransomware pandemic, things like that, not only was it, I think it was good for the company, but it was me also saying, hey, I am not whitewashing any of this. I'm putting it all out there. I want everybody to know the risk and threat environment that we're living in today.
Yep. And I think, the question, the way a lot of companies will do it is, as they're preparing the risk factors, right, as you've just described, right, what are the risks to the company? They should be typically coming to somebody who leads IT security, whether it's a director of IT security or a CISO, and saying, here's what we articulated as the risks. How have these changed since the last time we did a filing? And are there material risks that we really want to disclose? Because again, if you disclose those as risks, they're part of the defense that the company's going to use if one of them actually materialize, right? Because what we don't want to do is not tell the shareholders what the risks actually are and then say we withheld something, right? So that's the opportunity to say, look, ransomware is a big deal. Look, supply chain attacks a big deal. Look, if we have a business continuity problem caused by a cyber attack, right? If it's ransomware or even something else, that could impact our ability to deliver services or goods or whatever to customers or to our partners or so on. And so you really want to get into that. And there should be a process at most companies that are public where the team that's putting together disclosures are coming to the information security team, right, and saying, what are our actual risks, and making sure that those are adequately addressed and identified in the filings. So the answer.
One thing we would also do is if I made any significant investments in security. So if I did, if I implemented two-factor authentication, or I implemented, new encryption schema, or anything that was technologically significant, I would put those things in the 10Q as well, because we're mitigating risk by spending money by employing these new technologies.
Yeah, exactly. So let's take a look at some of the lawsuits that came out of this, because I think there's a question about in the chat about someone said, aside from getting laid off or fired, how much personal liability exposure is there for not just the CISO, but some of the lower level technical security staff, right? Low level managers, incident responders, sort of first line defense. And, and interestingly, right, Yahoo started something that we've begun to see more and more frequently. Now, this is not every situation, but we are seeing this more often, that they're naming individuals. Right before, the securities class action, wouldn't name security professionals. The consumer class action wouldn't name individuals. Now we're starting to see more and more of that. So, for example, in the Yahoo securities litigation matter, right? That's again when the shareholders are suing because the stock price has dropped. They named Alex Stamos individually as the CISO. In Equifax, in the shareholder derivative case, right? They named a number of different people. A number of different individuals in the shareholder derivative case, right? We then see the Equifax consumer class action also names a number of individuals. And who are those folks? Well, they're in IT security, right? At various different levels, right? All the way down to, people who are, corporate legal and security support at Equifax, the vice president of IT risk and compliance, the senior vice president of IT strategy and effectiveness, all the way down to IT governance. And so there's a lot of different people that just kind of got thrown in by plaintiffs' lawyers so they can put everybody in the crosshairs. And one of the things that we've actually seen from the FTC, so this is now the federal regulatory body, is the desire to hold individuals accountable. And so the FTC is stretching its legs a little bit and trying to see whether it has the ability to reach out and hold individuals accountable in their regulatory enforcement actions. Okay, let's go back to Yahoo. So all of this is going on, and what ultimately happens in Yahoo? So Yahoo took years to settle. It settled about 15 months after the 10K that came out from Yahoo. So we're now in 2018, sometime around May. And the SEC conducted its own investigation, completely independent, It asked for documents. It interviewed multiple witnesses. We were representing a witness in front of the SEC that testified for a couple days. And here's what the SEC said. Within days after Yahoo's information security team reached these conclusions, and this is about the exfiltration, members of Yahoo's senior management and legal teams received various internal reports from the chief information security officer stating that the theft of hundreds of millions of Yahoo personal data, users' personal data had occurred. The CISO communicated these conclusions to at least one member of the Yahoo senior management as Yahoo was negotiating the sale of its operating business to Verizon. That's a very different story, right? Very different story than what the company announced. But it took almost a year and several months for the truth to come out, right? So the SEC, totally independent, they got no dog in the fight. And what they essentially said was, no. The information security team did their job. They investigated this theme. They figured out that data was exfiltrated, and they went to senior management and legal to announce it. And it was the legal staff, right? However, Yahoo senior management and relevant legal staff did not properly assess the scope, business impact, or legal implications of the breach, including how and where the breach should have been disclosed in Yahoo's public filings, et cetera, right? Very different story. And I think one of the things that is the undertone or undercurrent of our conversation is, yes, there's criminal legal liability, which we're going to talk about, civil liability, which we've talked a lot about, but there's also reputational liability, right? And one of the things that, Mark mentioned in the beginning is, watch the Yahoo information security team get thrown under the bus 15 months earlier. It took that amount of time for the truth to actually emerge. So, okay. So now that's the parade of horribles that we've gone through for like 27 or 30 minutes now. Let's talk about key takeaways, Mark, right? Let's talk about some of the things that we think people in the incident response world or in the information security world should be doing, right, to help protect them in this context. And the one thing I want to mention, one thing before Mark kicks off with the first thing is to echo something Mark said in the beginning, which is really important. Most of the things we're going to talk about are if you do, it's where your interests and the company's interests align. In other words, by sort of doing some of the things we're going to talk about, you are not only protecting the company, you are protecting yourself, right? So let's talk about what some of those things are, because this is an alignment of interest where by following some best practices, by following some things that we've all heard and talked about, right, we can insulate both the company and ourselves. So Mark, do you want to take some of these firsts?
Sure. Go ahead and put them all up there. And I would say, these are the jacks are better to open requirements. If you're not doing these, you are doing your company and yourself a disservice. And I cannot emphasize how important number 4 is to document everything. One of the things that in Aravind and I's conversations with CISOs that have been involved with things is, it's, if they find themselves in litigation or find themselves testifying or answering questions, it is really hard to remember some of this stuff 2 or 3 years after the fact. And when you're sitting in front of Congress or you're sitting in front of the SEC and you keep saying, I don't remember, it just comes off as lacking credibility. And I even recommend to people that as part of this documentation that they actually have forms set up as part of their incident response plan that they can fill in these forms as they're going through these. And these become legal records at that point. So, number 1, detection, classification, escalation, and reporting. You have got to be able to, and I've said this for a long, long time. The worst time to try to start figuring some of this stuff out is during the middle of an incident. You have to have this documented and in place before an incident. This should be part of your incident response process that you test multiple times a year. Number 2, building this incident response team and the process for minimizing conflicts of interest. We saw in a couple of these cases where people in the company would end up, they become aware of an incident and then they sell their stock before this incident is made public. Well, come on, that's a no-brainer. You're gonna get caught doing that. So those kind of conflicts of interest, you have to think about those stuff in that. Investigating objectives, the root cause analysis, remediation, the whys of all of this that happened, and then finally this documentation. And again, I wish I could tattoo this on everybody, that document, because I guarantee you, and we talked to a number of people trying to remember the all of the things that happened and all of the steps you took and all the guidance you gave and all of the direction that you proposed. You're not going to remember that 2 or 3 years later. And in one of these cases that takes 2 or 3 years to evolve, you just simply are not going to remember all of those steps. And those things can end up costing you money.
Yeah. Let me echo what Mark said. This is so important. It's actually worth repeating, right? Let me just pick on two things. Let me pick on escalation, and let me pick on escalation reporting, and let me pick on documentation. So escalation is actually one of the most crucial areas that we see individuals fail and either lose their job or end up in a bad situation, right? The criteria for when an event should be escalated and to whom it should be escalated to, right, have to be laid out really clearly in your plan, right? And so that there's objective criteria so that as an incident responder, you don't have to ask. There's a bunch of questions in the chat, by the way. What's a breach? Is it this? Is it this? Is it this? And the answer is you don't have to worry about that. Let the knucklehead lawyers like me spend hours and hours trying to figure out whether it's a breach or not. What you should have in your plan is objective criteria that said, if this happened, this is what I'm doing. If this happened, this is who I'm telling. If I see potential for personal information is compromised, I got to call the chief privacy officer. I got to call the general counsel. Whoever it is and whatever it is, it doesn't matter. What matters is that you have a plan, that all of the relevant stakeholders have signed off on that escalation, on that severity assessment and escalation matrix, and they know when they're going to get the call. So that when you're in the situation that the incident responders at Yahoo are faced with, you can say, look, I did what I was supposed to do. You told me, I'm not a lawyer. You told me that this is when you wanted to know, and I told you. You told me below this you didn't want to know, and we didn't tell you, right? And so that's a real important thing. They have to be objective criteria and a clearly mapped out escalation process. Let me talk about, go ahead, Mark. I
was just going to say, and really important is that you follow that escalation process. If you skip steps, if you have documented a process and you skip steps in that process, you're putting a gun to your head, because you're going to be held accountable for skipping those steps. So it's a great point, right? If you say you're going to do it, right? I think that's the really key part. Don't just have a plan and not follow it. Let me talk about documentation for a second. And let me use Yahoo as an example. The breach that they were investigating was in 2014. And I will just tell you that the IR team and the paranoids that were working 15, 16-hour days for months. They couldn't remember when their kids' birthdays were, much less what happened on any given day. And here you are 2 years later, right? After you've spent 3 months burning the midnight oil, right? You've forgotten to shower, you forgot to change, you forgot to eat lunch. And now you've got some lawyer in a suit asking you, what did you do on a specific day, on a specific time, and who did you tell and what did you tell them? And you're like, I don't have a clue. For even if you did it yesterday, you might not remember. The documentation piece is to protect you and the company so that there's an accurate record of what happened when. And I'll tell you how bad it's gotten in some cases. We actually have a presentation that turned out to be the most key document in the case. And it was done in Google Docs. And what we literally had to do, because there was no record of who did what when, was we had to rebuild it in Google Docs in an animation. So you could literally see every single change that every single person made to that deck before it went to the CEO and the general counsel. And that ended up saving the butts of a number of people who had put changes in the deck and said, no, it was exfiltrated. Here's what I did, and here's my annotation. So that will help you remember, at a minimum, will help you remember what you did and when you did it, but it's also the record of how you followed your incident response plan and why what you did is completely defensible. So in the criminal world, we say it negates intent. I didn't deceive anybody. I didn't try to hide anything from anybody, because what I did was try to tell them exactly what was going on at the time it was happening.
So, you'll hear us as, you'll hear lawyers say document, document, document. I can't tell you how important that documentation has been to our clients who are in that hot seat. They can be able to go back and look at an email or look at a document that they put together or something and be like, yes, I now remember I did that at this time and said this to this person.
So, Arvin, and this is a legal question for you, that I'm sure somebody has thought of this, but if you can remember, Alex was long gone from Yahoo when this incident was being litigated, and you can, in many cases, 2 or 3 years later, people have left, and now you have a challenge of from a discovery process of even getting access to your notes or your emails that the company may or may not even have anymore. So, Arvin, what do you recommend as CISOs that how we deal with that with this record retention that you may not have access to?
It's a really, really good question, and here's the way to. And it's actually a fantastic question, Mark. And here's the way to address it: is as part of your IR plan, you should have a section that devotes to how will you retain records around this incident when it's over, right? So not for small incidents, you can have a small file entry in the file that says this is what we did in a short memo, but having a policy of how we keep records relating to an incident, how long we will keep them for, where they are kept, who is the custodian of those. So that, Mark, if you have left the company and now we're looking at it sort of hindsight 2020, and we're looking at it 2 or 3 years down the road, the company had an obligation to keep those records in a certain way for a certain period of time. And then if they didn't keep those, then you have an opportunity to say, look, how do you expect me to remember it? I built into our plan a way for me to remember these things, a way for our team to record what we did. If you went and blew all that stuff away, right, that's now on you, right? And so again, that helps the company though, because if you prepared those and you keep those for a certain prescribed period of time, and your legal team and your information governance team can tell you how long that needs to be kept for, that's the best defense, Mark, right? To make sure that those records are going to be there a year, 2, 3 years later, as the shit's proverbially hitting the fan.
Well, and you also have, the CISO may find themselves on the other side of the fence from the company where the relationship is not, it's not a gentle relationship. It's there's animosity in there where the company doesn't want to have access to this information because it could hurt them in the long run.
Yeah, and that's a great point, Mark, that we're going to segue to, right? When we talk about individual representation. So let's take a look at just some of the things that I think we've already talked about, Mark, a little bit, which are post-incident work and remediation. And I think we've covered most of these, Mark, but maybe there's something I call specific attention to.
No, I think maybe number 3 there. One of the things that we should always be doing is learning from our process. So as you go through an incident, and you document, wow, we thought that this person was going to be communicating to the shareholders, but it was actually this person, or we thought this person, you make sure that you can go back and do the revisions to your policies and procedures that reflect the reality and not the reality that you thought before an incident. So, being able to go back and actually build real life into their policies is really, really important.
Yeah, totally agree. Okay. So let's take a look at, just real quickly, because I think we want to get to some of the meat stuff that people probably have questions about executive and board engagement. Mark, you want to take this one?
Yeah, I mean, I don't think, listen, there's nothing earth shaking in here. Pre-incident, making sure this should be something that you have a discussion with your board about every quarterly board meeting. You're basically updating them on the risk factors, on incidents that they should be knowing about. I've always had I've tried to have a more of an open communications policy with my boards where I could even go, mid-quarter, out of cycle of the board meetings, and I could just drop the board members' notes to say, hey, this thing happened, it's not a big deal. Actually, I tried to stay in front of these because an incident like Colonial or an incident like SolarWinds happens, and the first thing the board's doing is calling the CEO going, WTF, are we impacted by this? So I always recommend having a good communication strategy and an open communication strategy with the board on pre-incident related things. And then obviously during an incident, CEO is typically going to be making the calls there, or general counsel going to be making the calls on how you're updating the boards, how you're trading blackouts, and working with the audit committee, and typically the CEO or the GC is kind of honchoing that's going to be beyond the CISO's role at that point.
Yeah, and I think the key on this is that doing the pre-incident things allows you to do the during incident things. Well, one of the things we hear from CISOs oftentimes is like, I don't understand a lot of that stuff. That's not my problem. It's not my job, right? To be worried about that. That's why we have the lawyers. And my response to that is, you need to build a partnership early with your board, with your management, with your legal team, so that they can help you lay the foundation, so that when you're in front of the board talking about an important issue, it's not being discounted. You're being taken, directly for what the words that you have are. You have access to them. They know who you are. So some of the pre-incident stuff helps you do the post-incident or the during incident stuff. And I think that's the other thing to highlight out of these, is that these sort of build off of each other.
And I always tell people, if you can find a champion, a security champion on the board, somebody that you can communicate with, out of band, between board meetings, that's the best thing, because that champion is going to be able to have discussions with the other board members. So then you look like the Lone Ranger out there, where you're always bringing bad news to the board.
Yep. Okay, so let's talk about the what about me's a little bit. Okay, so couple different things, right? And so a lot of these come out of Joe Sullivan's case, but these aren't unique, right? We've faced these when we represented people, whether it's in Equifax or when we represent people in Yahoo. There's a question about representation. Do I need my own lawyer? And largely what we would tell you is that the company counsel represents the company. Your individual counsel represents you. They have your best interest in mind. Now, does that mean you need a lawyer for every incident? No. Does that mean you might need a lawyer for an incident? Yes, right? The key to understand is that, again, what Mark and I laid the groundwork for is, if you're doing what's in your incident response plan, if you're following best practices, largely a lot of these issues can be avoided altogether, right? And so when you're acting in the company's best interest, you are actually generally acting in your own. And so you don't need a lawyer every single time there's an incident, but there are times that you do. And here's the reason, right? Because the privilege, the legal advice, that's for the company. That's not for you. They don't represent you, right? You don't actually maintain the privilege over those conversations. They can waive it at any time, right? And so you may need your own lawyer, right? The question is, when do I need my own lawyer? And the answer is, at the moment where you suspect that your interests and the company's interests are diverging is the time you need to begin thinking about that question, right? And there are a small group of professionals out there who have represented individuals, in the context of an ongoing event, in the aftermath of an ongoing event, right? And what it's important to know is you should be understanding who those folks are. Now, we're going to talk about another reason you need legal counsel in the application process for your job. And so you may already have a lawyer, right, that you can consult with. But I think the key is that, the privilege doesn't apply to you, that you may need to select your own individual counsel. Now, how does that work? And this is the question we get all the time. Okay, here's how that basically works. Certain executives have the right to select legal counsel by corporate documents, right, in certain events. And the company will pay for that. It's called indemnification, right? Where the company says, for these officers, if there's some reason that if someone's seeking to hold them personally liable in connection with certain events that they've taken within certain confines, right? The company will indemnify them. They will pay for their legal costs. They will pay for their defense. They may even pay the fines, right? That's usually found in corporate charter documents like the bylaws, right? And it's most often found for the Cs, right? The C-suite, the CEO, the CFO, and some others. Here's the key. Just because you have a C in front of your name doesn't mean you're indemnified, right?
Nope.
That's the thing we hear all the time from folks. It's like, well, I'm a C, I'm a chief something. Goes, not necessarily under the law, right? And so you should understand when you're thinking about a job is whether you have rights to be indemnified by the company, right? And I'll talk about indemnification in some more detail in a little bit. Even if you're indemnified, you may be, the company may, even if you're not indemnified, the company may advance costs or fees to pay for your counsel. And you may have rights to get advancement, whether it's under a contract or whether it's in the bylaws. And we'll talk about that in a second. But it almost is always accompanied by an undertaking to repay, right? Which means, yes, the company will front my legal costs, but if it's found that I did something that is outside the indemnification or the company is not going to pay for, I have to pay the company back for those legal fees. Here's the practical advice I will tell you about this one piece because it comes up all the time. Well, what happens when I've gone through all of this stuff and I paid you thousands and hundreds of thousands and sometimes even millions of dollars in legal fees, and the company then comes and says, you have to repay those? Generally, what Mark and I will tell you is if you're at that point, it's over. Right? You've got other problems that are bigger problems. I'm not saying that the repayment to your company of legal fees is not a problem. It is a problem. But by that point, there's usually some final finding of liability or guilt, right? That's going to be actually the bigger problem that you have. It's not the fees that you have to pay pay back to the company.
Probably not civil at that point.
Right. And a lot of our clients just say, if that is where I end up, that's where I end up, and they can come chase me for it. Right. Because I'm going to be doing 5 years in a prison, or I'm going to have no money otherwise to pay, or I'm going to have no job. So they can come squeeze, try to get blood out of a stone. Let's talk about how you act. Yeah, go ahead, Mark.
One more thing. So, and this has come up a lot, is how do you, as a CISO, when you're negotiating a job, how do you bring up the conversation around and bylaw indemnification without looking like, like you're going to be a C lawyer, and a problem child from the very beginning?
Right. So it's a great question. And here's the advice, right? You can't get it if you don't ask. And the reality is, right, more and more chief information security officers are asking for this. And it's not unreasonable given the use case that we talked about, given Equifax, given Yahoo, given Uber, and I'm sure there will be more, to have an upfront conversation and to say, look, I am a chief information security officer. I have serious, significant responsibilities to the company. I want to make sure I am doing those to the best of the company's interests. And I think what that requires is, just like every other C officer or C executive, is to have rights to indemnification, right? And so you can get those in one of two ways typically, one of three ways. You can get it by operation of law, meaning the statute empowers you to be indemnified. That's rare, right? Most companies are incorporated in Delaware. As a chief information security officer, you're not entitled under the Delaware law to get it. You can get it because the company has set it in the bylaws. They've said, here are the people who can get indemnification, right? And some of the language you see here on the slide is the kind of language you might see in the bylaws, right? In terms of what those indemnification rights will be. The other way you can get it is you can get it in a contract. So when you sign your employment agreement, right? Or you get your offer letter, right? And you sign it, right? You have indemnification rights there. And here's the reason that we talked about it. You should be, if you're taking a significant C-level position at a company where you're a CISO or a CSO, right? And you're going to have potential liability, these things might happen. You should be considering consulting with an employment lawyer to negotiate on your behalf, help you negotiate, to make the ask that Marcus suggests that you make, right? Because again, you ain't going to get it if you don't ask. So bite the bullet and ask the difficult question, because you want to know what you're getting. Right. And I can't say that enough, right, is you got to ask for it, right? Yes, it's uncomfortable. And yes, we really want that job. We won't do it. But you're showing and demonstrating a level of sophistication, right? And you can say, look, I know how these things go. I want to be in line with the company. I want to act in the company's best interest. When there's defense, I want the company and me to be aligned in how we're going to defend the company and myself when all of these allegations are made, right? And so I think those are the ideas that we really, those are the ideas that have to come front of your mind, and then you just have to ask. I don't, Mark, if you have anything you want to add to that idea.
No, I in my last job, I brought this up, and I was specifically not a chief of anything because the company did not want me. They had a very small executive staff to begin with, but the getting to be included in the D&O policy, the corporate D&O policy, was something I had to specifically ask and say, listen, this is a requirement of me to work here. And I get it. It is you feel like you're being a troublemaker from the very beginning by asking these questions. But as Irvin said, if you don't ask for it, you're not going to get it. And you're setting yourself up for incredible problems down the road if you end up in a security incident.
Yep. And I think that's an important point, right? The D&O policy is another way to be covered, so to speak, right? So that there is money to pay for your indemnification. The worst thing that can happen, and we've seen this happen before, is company says, oh yeah, I'll indemnify that officer, totally no problem. And then what happens is the company goes belly up and there's no money to indemnify them at all. A D&O policy can help in some regards in that respect, right? And so that's another reason to get your name on the D&O policy or be one of the directors that is insured by definition. So,
and one other really quick thing here, and I just discovered this recently, and it's probably should have been clearer before, but D&O typically will have a cap on D&O, whether it's 20, 50, $100 million. That's not per officer or per board member. That is an aggregation cap. So guess who's going to be at the bottom of that list? It's probably not going to be the CEO and probably not going to be the board members. So if the board members and the CEO use up all the legal fees in that D&O policy, you're going to be sitting there, with nothing nothing and no recourse.
Yeah. Okay. So just to give you a sense for what to look for, because a lot of clients have asked, well, what do I look for? Because can I get the bylaws and ask? And here's some example language that you might be able to find. I just pulled this from, you can figure out which the company is, their indemnification provision, but shall indemnify to the fullest extent permitted by the DGCL, that's the Delaware General Corporate Law, as now and hereafter, yada, 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 right? And it's suit or proceeding, whether civil, criminal, administrative, or investigative, right? These are really broad. They're saying pretty much anything, right? By reason of the fact that such person is a director or officer of the corporation or any predecessor. So you have to be an officer defined. It's not just because you have the title, it's legally defined, right? So let me get to one last thing that people ask about on these issues, and it's advancement and undertaking to repay. So again, these are in the bylaws for a specific company. You can figure out which one it is, but here's what it typically looks like. It'll typically say something like expenses incurred by the person who is or was a director by defending in one of those suits shall be paid by the corporation in advance. So they're going to hand you money to hand to your lawyers. And I will just tell you that we know this from experience that the bills, when you're really in the midst of these, can be in the hundreds of thousands of dollars. We've had executives where the bills are in the millions of dollars, right? Because you're fighting for your own personal stake, right? And it's in advance of the final disposition of suit or proceeding, provided, and this is the undertaking to repay provision, provided that it's made only upon receipt of an undertaking by or on behalf of such persons to repay the amount if it's ultimately determined that such person is not entitled to indemnification. Again, that's the least of your problems at that point, but you will have to sign an undertaking to repay those costs. So just to kind of recap the personal side really quickly, right? The key things to think about are, what do the bylaws say? Are you an officer under the bylaws? Are you indemnified under the bylaws? Will they advance your fees? Is there an undertaking to repay? And if it's not in the bylaws and you're pre-employment, can I negotiate for it, right? Or can I get it as a renewal of my contract, right? And there are moments in time to begin to ask for some of these things as a prospective employee to the company. And companies should be in a position of evaluating those and considering them, right, in good faith, because it's not that you are, as Mark said, trying to pull yourself away from the company and trying to say, like, I'm going to be nervous about this the whole time. I'm going to be looking to throw somebody else into the bus. It's because by doing these things, you better align yourselves with the interests of the company. So I think, Mark, that's our presentation. I think we've got a couple minutes. I think we've answered most of the questions in the chat. But if there's other folks that have got questions, they can throw them in the chat. Or if, Mark, you got any parting thoughts, I think now is a good time to do them, right?
I would just go back and document. Make sure that your employment agreement at least addresses these things, and you may not get your company to agree to it. But I would at least have to try to get this put on ink and paper at the beginning.
Yeah, and I would agree with that 100%. I think the key is you're not necessarily going to get this every time. You may not even want to ask for it every time. Although if you don't ask, you're not going to get it. But I think the key thing is we want everyone to think about this. So go into that job being informed, right? The only way you can make a good decision about yourself is if you have all the information. And so the goal of this is not to scare you. It's not to say you need to do X, Y, or Z. It's to arm you with the information to understand what the ramifications should be so that you can make a decision in the next job I take, in the job I'm about to take, in building my incident response plan. Am I doing all the things that both protect my employer and myself?
Yep.
Great.
No more questions? I can't see the questions, so.
I've seen the questions, and I think the only questions about the slides being made available, you can certainly email Mark or myself, and we would be happy to share a copy of the slides with you. All right, I think that's a wrap, Mark. We got done early.
It's never happened before. Of course, they've always been in person before. Yeah.
Well, the only thing I can say is Mark and I were both remarking how we presented at RSA last year when we were in person in San Francisco. And so we hope that the next time we're doing this, we're all in the same room with you all together, shaking hands and sharing a drink with all of you. So thanks to everybody for listening, and we'll talk to you soon.
Thank you.